Hello everyone and welcome. My name is Dan Sampaio and I'm delighted to open today's Mondaq webinar in association with Adams & Adams, which will take a strategic look at IP protection and enforcement in Africa. Adams & Adams is an internationally recognized and leading African law firm that specializes in providing intellectual property and commercial services, with primary office locations in South Africa and branches and associate offices in a number of African countries. The firm's leadership position is reflected in the groundbreaking work they do, the valuable client relationships they have, and the quality of their professionals. More than 200 professionals specialize in various legal and technical disciplines in intellectual property law, commercial and property law, and litigation. The intellectual property law practices work with clients around the globe and across many industries to protect, enforce, and commercialize their intellectual property, including trademarks, patents, copyright, and designs. And we are joined by a wonderful panel to take us through today's discussion. Nikki Garnett is the head of Africa Patent Section of the Patent Department, a position she has held since 2008. Nikki is originally from Zimbabwe and moved to South Africa in 2008. She obtained her law degree from the University of Natal in 1997, and in 1998 she began working with a leading law firm in Zimbabwe specializing in intellectual property. Nishan Singh is a qualified attorney and trademark practitioner who has been a partner of the firm since March 2012. Nishan advises some of the world's top multinational organizations on the protection and enforcement of their brands and related intellectual property in Africa. Nishan has extensive experience with litigation proceedings related to intellectual property in the High Court, the Tribunal of the Registrar of Trademarks, the Companies Tribunal, and domain name dispute resolution providers such as WIPO. Simon Brown's practice focuses largely on clearance investigations, filing and prosecution of trademark cases, and trademark portfolio management throughout Africa and internationally. As well as being a lecturer in international trademark law for the South African Institute of Intellectual Property Law, Simon is actively involved in a number of committees for both SAIIPL and INTER. We are also joined by Ogie Williams from INON Africa and Sarah Brout from Caterpillar. Ogie has been with INON Africa for 6 years and has extensive experience in research, qualitative and quantitative data analysis, project management, and reporting. His research experience has covered the majority of the African continent, with numerous projects focused on market expansion and industry sector trade analysis. Sarah is a UK qualified chartered trademark attorney working in-house at Caterpillar. As a trademark attorney at Caterpillar, Sarah is responsible for enforcing and protecting the well-known Caterpillar trademarks in Africa. Now, before I hand over to the panel, a housekeeping item. You are able to submit questions to our panel by typing questions into the control bar on the right-hand side of your page. You're able to submit questions at any time, and we'll endeavour to answer as many as possible during our Q&A at the end of today's webinar. It's now my pleasure to hand you over to the panel and Ogie to begin. Thank you.
Great, thank you so much, Dan, for those introductions. So, as Dan already alluded to, my name is Ogie, and I'm the representative of Adams Advisory as well as INON Africa. We work throughout the continent on various sectors, industries, and guiding clients on ways and strategies to get into Africa, as well as better understand the environment in which they operate. So, to lay the foundation that's ahead of us in terms of intellectual property and trademark discussions, I thought I'd lay some groundwork just in terms of putting a high-level view of Africa for everybody that doesn't really have much of an understanding or much background knowledge pertaining to the continent. If we go to the first slide of our presentation, it essentially just paints a very high-level view of the development that has undertaken and is continuing to take place throughout Africa. Though the last couple of years have been quite difficult, the GDP outlook is improving with growth rates on the rise, and we are projecting quite a stable 4% for the rest of this year. If we look across the regions, a number of countries are continuing to make strong headways in terms of GDP per capita, with ranges across all 5 regions in Africa at a stable 6,000 to 12,000 US per capita across all markets, which signifies that growth continues to take place, even though the last couple of years have been challenging, as I mentioned. At the same time, we also see that there is movement in terms of IP block membership, with some members across the continent already taking membership to OIP as well as a repo, while others are still in the process of actually onboarding. However, they do have some connections to various protocols, which my colleagues will allude to later on in the presentation. If we look a little bit more granularly into the various industries that are essentially shaping up the economic growth and development of Africa, notably the last couple of years, pharmaceuticals, a big talking point in lieu of the COVID-19 pandemic, in terms of what is the capacity which Africa can bring to the table in terms of manufacturing, as well as what rights does it have towards production of local patents. At the same time, we see that mineral resources continue to drive growth on the continent. We are home to a bulk of the gold as well as oil and gas reserves that are located throughout the world, as well as huge potentials in terms of chromium, which are likely to be even more on the agenda as the energy transition takes shape. Something to continue monitoring going forward. For those of you that do not know, the information and communication technology sector in Africa is moving very strongly ahead, with financial services being strongly integrated in communications technologies, bridging the digital divide between access or financial inclusion and access to capital is taking place in the digital realm. And we can see that transactions across board have increased, as well as the values and volumes of those transactions. And the uptake of registered accounts via mobile platforms has also increased significantly in the last few years and continues to do so. In fact, the last couple of years have seen these transactions shoot up significantly off the back of COVID-19, movement restrictions, and the need to increase financial inclusion without actually the need to move around geographically speaking. So all three sectors offer good potential for Africa and are continuing to drive industrial development and growth. And in parallel, we can always see the growth as well as the movement of the FMCG sector as urbanization takes place, as the population growth of Africa continues to take shape. And as we can see, we are projected to hit 2.5 billion by the year 2050. The FMCG space, coupled with information and communications technology, are likely to drive a lot of the economic growth in Africa going forward. But as I say, pharmaceuticals is also a big talking point as an industry, as well as mineral resources. There are, of course, other things that we need to take into account. If we look at the next slide, there are various opportunities that need to be considered by investors that are looking at trade and investment in Africa. Probably the big talking point that has been on the agenda for the last few years, especially over the last 2 years, again, over the COVID-19 pandemic, is the African Continental Free Trade Agreement area. So for those of you that are not quite aware of what the AFCFTA means, it is essentially Africa's answer to the Eurozone. It looks to establish a single market for trade and investment across the entire continent, pooling all 55 African nations under one umbrella. If we look at the numbers of the AFCFTA, they are significant. The GDP contribution that is going to be put on the table over the coming years as the agreement takes shape is over 3 trillion. At the same time, it will encompass all of the regional blocks across Africa and facilitate that movement of trade, starting all the way from Southern Africa through to West Africa, North Africa, and essentially ensuring that there's a circular trade and investment pathway across the entire continent with one set of rules and regulations pertaining to trade and investment. There are naturally aspects that are still being ironed out, but the agreement is moving forward quite smoothly and progress has been made. What we can see in the last 2 years, as indicative by some of the data, is that investment is moving forward and a lot of it is being directed towards Southern Africa as the driver of trade and investment off the back of the AFCFTA. But I must say there's also a significant development in West Africa, looking at single currency pool markets in the East Africa region as well, in terms of integrations in trade between Uganda, Tanzania, and Kenya, as well as certain portions of North Africa as well. So that's just a snapshot in terms of investment and trade opportunities. We move to the next slide. There's also a little bit more granular data in relation to what are some of the big considerations and challenges that everybody should be aware of when dealing or looking to enter into Africa. Again, COVID-19 has posed challenges over the last 2 years, but not as many as perception would be from others across the world. There is still trade, there is still investment, but there's been a significant influx in the cost of living as well as challenges in terms of movement that has declined in the last 12 months as movement restrictions have essentially dropped. And we also see that there are certain initiatives by government to also tackle broader security and conflict issues. You can see that more prominently in Western Africa, but also in some certain places in Southern Africa, like Mozambique. But notably, there have been efforts made in both regions to tackle the security situation. Broadly speaking, those are considerations, or those are challenges that need to be taken into account. In parallel, the very current ones, which are at the top of mind of many investors, as well as a number of countries throughout Africa, is the impact of the Russia-Ukraine conflict in Europe. This can be evidenced by some of the data. There are a number of markets in Africa that are very dependent in the agricultural space in terms of imports from those regions. At the same time, the impact on the oil and gas sector has been significant. As we've all noted, the prices have gone up per barrel in the last 2 months significantly. Though the projection is that they will tail off by the end of the year, there is a certain impetus that in order for that to happen, Africa has to be a key role player in regards to setting up new projects, getting moving with projects that were previously stalled off the back of movement restrictions and uncertainty in regulations. So that is a big consideration and a big talking point, and it's probably the biggest across the continent. It also poses a good opportunity for us to look at what else is there that Africa can bring to the international arena. And as can be noted, the outlook is positive. Like I mentioned, 4.4% in terms of projected GDP growth, as well as an increase in trade off the back of additional motions made by the AFCFTA. But the outlook is positive, and we are anticipating quite a bit of positive movement over the rest of the year and going into 2023. Just to touch on a few of the important points that my colleagues will unpack in more depth regarding specifically intellectual property and trademarks that my team has noticed over the recent months. The next slide details some of the developments that have taken place regionally. And what we can see is that the talking point is again the AFCFTA as one of the potential regulations or pieces of legislation that will be continuously aligned going over the rest of the year, as well as various governments aligning towards the broader agenda of the agreement. Below that, we can see that there's specific and independent motions by the various legal blocks like OAPI and ARIPO. Different discussions have taken place over the last months. We can also see that Cape Verde is now the most recent member of ARIPO as the 22nd. So there is additional motions by states across the continent to move into the legal space and to become members of organizations and blocks like ARIPO and OAPI. And then more granularly, we can see the same taking place within the individual regulations and legislation in terms of intellectual property rights and trademarks per state across Africa. The ones that I wanted to allude to are Egypt, Nigeria, and South Africa. Each of them pose very interesting spaces with regards to legal and regulatory developments. One crossover that we have seen in the cannabis space is between Morocco and South Africa. Both have updated regulations with regards to the industry. And we also see that in the financial services space, Egypt recently passed its first fintech law. A big question mark in Nigeria have been counterfeit goods in recent years across industries and sectors. So the country has taken proactive steps to try and set up various regulations and mechanisms to actually manage all of that. So that particular market, I think, should be observed more closely by everybody. Reason being is that although motions may seem slow and taking a long time, they are still taking place. And the government has put a big impetus on actually buying up counterfeit production of various products. One that I can refer to is the printing industry. In the last 2 years, there have been various operations between major international companies such as Hewlett-Packard and the Nigerian government in terms of stopping counterfeit operations for various consumables and products. And as I said, that's just one industry that I can allude to, but there are others. So with that said, there's a lot of opportunity that Africa will present. As I say, economically speaking, we are in a positive, even though it may not appear that way, despite the stagnation and potential recession that's happening globally. Industry-wise, we are still strong participants in various sectors such as financial services. We want to participate more strongly in pharmaceuticals as well as the energy space. We are tackling various challenges that we are aware that the world is obviously critiquing, including conflict and terrorism, as well as copyright laws. And as you can see with this final piece of data that I wanted to share with everybody, we are moving on the legislation aspects as well. So that's just a very quick high-level view of Africa for everybody that is not that familiar with the continent. And as I say, my colleagues will expand on each of the points through the various more in-depth points about legislations and regulations. But from my side, that is everything. Thanks so much, Dan.
Thank you very much, Ogie. Yeah, so now that we have a bit of a snippet of the African economy, I'm going to be talking about the enforcement of intellectual property rights. And my first slide really is, I mean, you'll see it's a heat map of the countries in which we litigate the most in Africa. So the good news is 53 out of the 54 countries in Africa don't have IP laws, and we've litigated in most of these territories. The heat map really presents where we've litigated. So the countries that are colored in red and orange are the countries where we've litigated the most in the past year. And those in yellow and white, we've had fewer cases. What I find interesting about the countries in red, Ogie, and going back to your presentation, it closely corresponds with the countries that you've mentioned where there's potential for growth and where the GDP is quite high. So if you look at South Africa is in red, we've got Kenya in red, we've got Morocco, and then we've got a large part of the west of Africa in red. Now, if I could touch on the west part of Africa, that's really one of the regional systems that we have in Africa, and that's the OAPI system, the OAPI system. 17 countries form part of that system, and it makes it fairly easy to litigate, hence the countries being colored in red. The other regional system we have in Africa is a repo, and that's towards the southern parts of Africa. The countries, most of the countries in orange on the southern part of Africa is part of a repo. And one of the questions that we were asked leading up to this presentation is how can a repo streamline the opposition proceedings? Now let me give background. The reason for that question is as follows. If we had to compare the OAPI regional system with a repo, OAPI, all the member states have effectively renounced their local IP laws. So they're following one system, and if you file any litigation or oppositions for that matter, it's one opposition is filed. Now that's contrasted with a repo where you have to file an opposition with the repo office in every designated state. Well, every state that's been designated in the trademark application. So it's difficult. It's difficult in the sense that it's difficult to streamline because you have to follow both the repo system and the country's local laws. I want to answer, I think, the most pertinent question that clients ask, and that's how expensive is it to litigate in Africa? And to be honest, you can't really compare it with the costs that are incurred in litigation in the States, for example, or Europe. Most of the cases that we file in Africa are simply not defended. I would go as far as to state that 80% or more of the cases that we file are not defended. So, for example, in Nigeria, if you have to file an opposition and it's not defended, the mark is simply marked off as abandoned. So there's no hearing, costs are limited. Another way in which costs are fairly low, the reason for costs being fairly low is that the matters are dealt with generally on the papers. So in places like OAPI, when you file an opposition, the opposition is signed by an attorney, which makes it fairly easy for a client to litigate. In other countries like South Africa, a client is required to sign an affidavit, but there's no requirement for witnesses in such cases. So we can manage the costs insofar as litigation is concerned. I want to actually bring Sarah. I'd like to bring you into this part of the webinar, because I guess the key question is how does Caterpillar protect its valuable brand in Africa?
Thank you, Nishan. So there are many brands in the Caterpillar family. We've got the Cat and Caterpillar flagship brands, and then we've also got various subsidiary brands such as Perkins, SEM, FGW. And we do see a number of trademark and IP issues that affect any number of those brands. And so we're always looking for ways to protect those. In trying to protect them, we take action against a number of different misuses. We look for misuses on shop fronts, so brick and mortar issues. We have online and domain issues, which we challenge. We also take action against people using our trademarks in their company names, and also efforts on the anti-counterfeiting front. Another way that we try and protect our brands, especially relating to counterfeit activity, is by looking to see whether we can get customs recordals in place at some key ports, and for those that customs recordals are available. And we also have a look at what's going on the registry. So looking at whether there's third-party marks that we need to file oppositions against or cancellations. So as well as looking at what's going on in the market, we're also looking at what's going on in the registry to help us protect our various brands.
Thanks, Sarah. I mean, do you use some sort of watching service for Africa?
We do, yes. So, you know, because it is so important for us to keep an eye on, you know, what third parties are filing, particularly because it's always better with deadlines and everything to be aware of the more problematic marks sooner rather than later. So we do actually use the Adams & Adams Kipanga service, and we also have a US global watch service keeping an eye on what's being filed too in Africa.
Yeah, I mean, it's always advisable to have a proactive approach to these things. I mean, you mentioned the Adams & Adams Kipanga service. So what we've really done, we've partnered up with one of the best watching service providers, and that's CoreSearch. And all clients that have trademarks on our system effectively get a free watching service throughout Africa. And the value add with Kipanga, which you've mentioned, is what we do is, I think we all know with watching services or clients that have subscribed to watching services, it's excellent because, I mean, effectively you're notified of third-party applications, but there are a lot of irrelevant results that you receive. And what we do with our Kipanga watching service, essentially what we do is we filter those results that we receive from CoreSearch, for example, and those are filtered by professionals. So when a client receives a hit or watching letter, it's more than often than not, it's more relevant, and it's something that you'd want to proceed against. So if I could then move on, I mean, to really my next slide, which deals with the protection of well-known trademarks. And I mean, a well-known trademark really gives you a trump card in litigation, right? And the good news is a fair amount, 46 African countries to be exact, afford protection to well-known trademarks. So that's, I mean, it's great. The difficulty comes in with the onus of proof. So when you rely or you try to enforce a well-known trademark, you have to prove that it's well-known. And I say it's difficult because we ask clients a whole range of questions. So starting off from, okay, when did you adopt your mark? Where did you first use it? Where is it currently being used? You know, I mean, for what goods and services? What's your annual sales figures? What's your marketing expenditure? Can we get examples of adverts? Essentially, what we're trying to do here when we send clients this whole list of questions is we're trying to collate evidence to prove that a mark is known in a particular territory, because that's what you need to overcome. Social media has helped us a bit. If you can show that you have fans or followers on your social media pages from a particular territory, we certainly use that in evidence. Website hits also are very relevant. But I mean, Sarah, you probably often get these lists of questions. Can we get all of this? So, I mean, if you could help us out, what difficulties as a client do you experience in evidence collation? CAT is well known, obviously. It's a well-known trademark, but evidence is not an easy thing to collate, right?
Yes, definitely, Nishan. And, you know, we do definitely see the benefits, but, you know, it is very, very difficult for us. And in such a big company like Caterpillar, one of our main difficulties is actually trying to hone down, you know, what we're looking for and getting the right contacts to go to. And they could be anywhere in the world that are coordinating, you know, figures specific to the region that we're looking to prove, you know, our reputation in. So yeah, really the difficulties for us are just making sure that we know exactly what's required so that we can really try our hardest to pinpoint the correct, you know, commercial contacts that can help us with that. and also really time consuming. So just making sure that, you know, we've got enough designated resources internally to make sure we can provide all the evidence that, you know, we've been asked to provide, and, you know, kind of give us the best position that we can to help have that well-known status. So yeah, really time, resources, and identifying the correct contact can be our main difficulties.
Yeah, I mean, insofar as you've asked, I think you did ask the question of me. So where do we see good fame cases, you know? And to be honest, South Africa is maybe a sort of bias because I'm based in South Africa, but South Africa is really at the forefront of development of legal IP jurisprudence in Africa. So we've got good cases on fame law, you know, I mean, that help us insofar as what is required to show that a mark is well known. There have been good cases coming out of Kenya, but we've enforced well-known trademarks throughout the continent. So I mean, a couple of countries that come to mind: Morocco, Mauritius, Mozambique, Wapi as well. So if you have a well-known trademark, it certainly can be enforced. The next slide, which I'll be touching on, it relates to really the fallback position when it comes to enforcement, and that's user rights. Okay, so we're dealing with a scenario here where the client doesn't have a registered trademark in a particular country. Its trademark is not well known, but it is using its trademark in that country. So it has it alleges that it has a reputation. The question that is then asked is, okay, is this a viable strategy for enforcement in Africa? I mean, how many countries can you actually enforce user rights? And there it is in front of you there. I mean, they're not many. There are 10 out of 54 countries in Africa where you can actually enforce user rights, and that's what, 18.5%. It's a very low percentage. So the strategy for enforcement of user rights, or relying just on user rights, it comes with a degree of risk, because you have limited options here. And of course, again, it's the evidence that you have to collect to prove that reputation. The one thing that I want to touch on user rights relates to clients that are not using themselves in a particular territory in Africa, but their use is actually through a licensee. So I mean, a scenario, for example, you've licensed a licensee to use your trademark for services in a particular country. You need to be careful, and I'm speaking now to clients. You need to be careful of certain mandatory license recordals. So countries like Botswana, Swaziland, Namibia, there's certain countries where you have to record a licensee as a registered user, failing which that use by the licensee is not recognized. And I'm mentioning it here, Simon, because it relates to enforcement in the sense that your mark could potentially be vulnerable to cancellation based on non-use, even though you're using it, because that use is not recognized. So just be aware of this mandatory record or requirement in certain countries in Africa. The next slide deals with copyright protection, and I think most of us on this webinar would be familiar with the Berne Convention, which is really an international agreement governing copyright. Copyright is unfortunately I would say the forgotten IP right when it comes to enforcement, and that's really a pity, because copyright gives you wider enforcement opportunities. Okay, especially when you're dealing with something like enforcement of a logo. Remember, all that is required for copyright enforcement is you need to show copying, so adaptation or reproduction, right? You don't need to show similarity with goods, or you don't need to show confusion as required for trademark infringement. So really, it's something that proprietors or clients should keep in the back of their mind. Make sure that their copyright is in place and they can prove that they are the owners of their copyright, because 46 out of the 54 countries in Africa are signatories to the Berne Convention. So you can enforce your copyright in those countries. The most notable country that's not a signatory to Berne is Nigeria. That's where we litigate a fair amount, but we often come short insofar as copyright is concerned. But there have been a lot of developments on the, I mean, Ogi alluded to it in his presentation. There have been a lot of developments on the copyright front. in a couple of countries. So Nigeria and Kenya have recently passed copyright bills to bring in line their copyright laws with international standards. South Africa is dealing with a copyright bill. The president actually referred the bills back to Parliament to just bring them in line with certain constitutional requirements and international obligations. But there will be soon developments on that end. So yeah, copyright. That's something that I think we must always keep in the back of our minds. Then my final slide, and that deals with international trademark registrations, which in theory is a brilliant system. Okay, you effectively get registration in several countries worldwide, but reliance on Madrid, on the Madrid system in Africa, comes with a degree of risk, because you need to bear in mind, in order for Madrid to function effectively, the local IP office needs to have no backlogs. First of all, it needs to have a single digital system, and most of the countries that are members of Madrid, so the 21 countries in Africa that are members of Madrid, come a bit short. So I've listed 4 countries where we have enforced international registrations in Africa successfully, and those are the countries where we advise clients to effectively tick the box. OAPI, so the Bangui Agreement has been recently amended, and that now gives effect to international registration, so they can also be enforced there, which is really great news. Just be careful. I think when it comes to Madrid, it's possible in certain jurisdictions, but others you need to make sure that you actually have a right. I think that's the end from my side, but I would like to end my webinar by Sarah going back to you and asking you really a closing question from my side, and that's what experiences or differences in enforcement models have you seen as a client in Africa?
So for many years, really, we've had exposure to, very different enforcement models across Africa, all the different countries and also throughout the world. And I think the thing that, really is important for us, and we recognize how, complicated and, potentially tricky that litigation can be in Africa. And I think from, a multinational global company's perspective, that's why it's so important for us to know that we can, rely on our outside counsels who have that in-depth knowledge and understanding of all the little sort of nuances and the specific laws that, we can't be aware of ourselves internally. So, that having that in-depth knowledge and understanding that Adams & Adams does, it's so important for us to have that due to the complexities. And also the benefit of that is because of those complexities, then kind of having our outside counsel allow us to help execute our business strategy, bearing in mind, what we need to be aware of in the different territories. I would say the other enforcement model difference that I've seen in Africa is that the close coordination and relationships that we have between, our outside counsel, us as the client, and also external investigators that, maybe we as the client have instructed, and just how important it is for them all to integrate and have conversations together, and especially in counterfeit matters. And that's not something I've typically seen in, for example, Europe. There seems to be more of a closer collaboration in Africa for the enforcement model.
Great, thank you so much, Sarah. I'm going to then hand over to Simon and Nikki.
Well, thanks, Nishan. And thanks, Dan, for the intro. Just a reminder, my name is Simon Brown. I'm on the trademark prosecution side. And today, in our presentation, Nikki and I are going to do a tag team. So Nikki Garnett is basically my equivalent on the patent and design prosecution Africa side. So we'll be jumping in during our presentation and obviously involving Sarah as well, and fire a few questions at Sarah. Just in terms of strategy, I think the African, when you're trying to protect your IP in Africa, it certainly requires a somewhat unique approach, probably different to anything else that a proprietor would look at anywhere else in the world. There's different Already Nishan has alluded to them, and we'll go into that in a bit more detail. There's regional systems, there's national filings, there's Madrid, and a bit of a combination of these is really what you need to look at. In a lot of cases, some of them don't work effectively. You need to come up with another strategy. So it is a bit of a unique system that you need to adopt when protecting your IP rights in Africa. Just next slide, please. In terms of the old adage many years ago, certainly in Africa, used to be that cash is king. And whilst we've moved on since those days, certainly, our view is that the trademark, patent, or design registration is now king. Really, without that registration, that will sort of be the theme of what we're getting across today. Is without that registration, in many instances, you really have got a problem. Nishan alluded to user rights, but in a lot of instances, that's not going to be enough, and that's sort of going to be the theme as we work our way through the presentation. Just as a bit of a snapshot, so back in 1994, Madagascar, which is the 4th biggest island in the world, had absolutely no IP system at all. Its first law came into force in 1994, and I had the honor and pleasure of going across and filing the first ever trademark in that country. I went along with a giant bag of local currency and filed the applications. In fact, I think the first trademark ever filed is Coca-Cola, and I think Adams and Adams might be the second one. And it just shows how far things, and what that was 28 years ago. And some 4 years after that, the Mozambique adopted its intellectual property laws back in 1999, and again we were there, filed the first trademark application. This time it was Adams and Adams was the first one, and the second application was in fact Coca-Cola. So we had to change the order up. But it's amazing how laws have come a long way since that. I mentioned there that 53 out of 54 African countries have working IP systems. Slightly different for patents and designs, maybe 1 or 2 less there, but certainly when it comes to trademarks, you can pretty much get some form of protection across the continent. Maybe the only outlier is Eritrea, and that seems to, they seem to be on their own for everything. They, in fact, Ogie mentioned the African Continental Free Trade Agreement, and they're in fact the only African country that refuses to sign for some bizarre reason. So they, except for them, we're now doing quite a bit of work in Somalia. Their new law hasn't actually come into force yet, but they've got a deposit type system, which we believe will transition into the new law once that comes into force. So those rights will be worth something at this stage already. So it really is, it's amazing what's happening, where these laws were 20 years ago and where they are now. Basically, a lot of these laws are really in the infancy. If you think about some of the countries that say only had no laws 20, 30 years ago, where they are now, it's amazing. That sort of ties in with Ogie's point about the economic development and investment, and that's taken place, really literally in the last 20, 30 years. And that has tied in with substantial improvements on the legislative front. I think of the laws around the continent, it's probably only Zambia. I mentioned Somalia, but that's coming on board, and it's got its own issues. But certainly, as more emerging economies, probably Zambia is the only one that needs a new law. And in fact, that law is now currently at Parliament, and we're expecting a new law to come into force this year. So it's amazing how things have developed on the continent as far as IP legislation is concerned. We'll just make the point there about the cost of securing registration. Nishan alluded to it on the litigation front. It's not expensive, and certainly on the prosecution, filing, registration side, it's actually fairly inexpensive. And certainly it's worth, the issues that you might have in trying to rely on user rights, as opposed to just getting a trademark or patent or design registration done, it's just not worth messing around. And I say the costs are not extremely expensive. Most African countries operate on a first to file basis. You'll notice there from Nishan's slide about how few countries where you can rely on user rights. So really our adage is, get in there, file as quickly as you can. Honestly, it's just not worth messing around. And there's more advantages to, other than the obvious one of the trademark registration in terms of, of infringement, etc. There's other reasons why you also want to make sure you've got a trademark registration, and we'll will allude to that as we go through the presentation. On that point, if I can bring Sarah in early in the day, how does CAT determine what trademarks to file for in Africa?
Thanks, Simon. So I would say there's a range of factors. You know, we're more than just the CAT brand and the CAT logo on a construction machine. We're active in so many different industries: construction, as I say, marine, oil and gas, and also we've got a really extensive merchandise product line. So with us, we're always sort of talking abroad, looking at a broader approach. And I would say what we kind of look at when we're deciding what to file in Africa is, sometimes looking at what infringers are doing in the market, in the local market. And again, sometimes we rely on our outside counsel to be our, eyes and ears on the ground, so to speak. And they kind of bring to our attention, counterfeit issues or infringements out there. And sometimes that allows us to identify gaps in our portfolio. So if we're seeing a particular good that's, being infringed and our logo's being put on it and it's not currently in our product line, then we can feed that information back to our business and see if maybe it's a gap in our portfolio that we may wish to consider. So again, that can then build into, what we decide to file for in relation to goods. And also if we're sort of looking to have a global filing project and, we're moving into a new area, with it being so cost effective, again, we have to look at what we can file, if we can file for more specs and across more countries in Africa. And I would say finally, we look at, maybe the potential for filing innovative marks. So sometimes, we file for the actual mark, like our cat logo or a caterpillar, and sometimes we give ourselves the chance for more broader enforcement options. So we look to file for components of that mark. So maybe just the yellow triangle on its own, for example. So again, really that all builds into our bigger picture of, looking at what our business strategy is, what it makes sense to file for, and how our outside counsel can support us with that.
Cool, great, thank you. Right, next slide, please. You'll see the next few slides are just, and sorry, you're getting an overdose on the Africa map, but it's important that you all when you walk out of here, you must know exactly where all these countries are. I think a lot of people still see Africa as one place, and it's actually 54 places, all with their own identity. So it is important to keep track of all the countries, and we obviously very passionate about the Africa map. Just in terms of the background to the various laws, really effectively you're looking at 3 or 4 bases, the laws being derived from, and it's the first slide really talks about the former Portuguese protectorates, being those 4 countries, and we'll circulate the slides later. There's a bit more detail on timing, opposition periods, and so on. But that's just really to give you of what sort of laws are in place in the various countries. Next slide. And that's really just, so that's the former French. Obviously that's quite, there are more countries involved there than Portuguese. And in addition to that, we haven't actually pointed out the RP countries there, and that's another 17 countries, or the bulk of them. There's 1 or 2 Portuguese ones there, but the bulk of them are really French-speaking countries. So France has had a major influence on the laws in Africa. And as these laws have developed, there's certainly, if you look at the French law as it stands today, which is really the EU law, the synergies are, within these countries are almost identical, particularly as these laws have evolved. So previously, you had some laws, for example, in Burundi and Rwanda that were very outdated and were based on old French civil codes. But as these laws have developed, they've taken sort of a smidgen of that information or those provisions, but it's very much really European Union law that's sort of in place in those countries. And then the final one, next slide, is the former British protectorates. There, a lot of them where user rights are possible, and that also obviously includes South Africa. You'll see that we've managed to annex St. Helena, which is not African, but we've decided to annex it. No, seriously, we do a lot of work directly with the registrar in St. Helena. It's really just an extension of a UK right. but it's an island. In fact, it's not even on the map. It's so small, but it's really in line with Angola, as where St. Helena pops up in the middle of the Atlantic there, and we do a bit of work there. So really, the South African law is very closely aligned to the British law, which is effectively the EU law. Right, and enough of me droning on for a second. If I can ask Nikki to jump in. Next slide, please.
Perfect, thank you. Thanks, Simon. So as Simon indicated, I'm basically his mirror image on the patent and design front. So we're going to, this next slide takes a quick look at basically the patent and design landscape in Africa. Obviously, we've got, like Simon said, an overload of Africa maps, but on this one specifically, the countries in the dark blue are the ORP member countries, and I mean, we'll discuss each region separately in a couple of slides' time. So the countries in the dark blue are the ORP member states, and there we've got the same member countries for patents, trademarks, design, basically covers all forms of intellectual property. The countries in the lighter shade of blue are the ARIPA member states, and this is where there's a quite a big difference between the ARIPA member states for patents, designs, and utility models versus the ARIPA member states for trademarks. So those are the two regional organizations that we have in Africa, covering, 36 out of the 54 countries on the continent. It's possible to get patent or design protection in all countries in Africa, except for the 3 countries highlighted in that sort of burnt orange color, Somalia, South Sudan, and Eritrea. I think there is a slight difference there, like Simon and Nishan alluded to, with I think it's Somalia where you can do stuff in Somalia. But as far as patents and designs are concerned, there's no protection available. And then something that's a little bit more interesting and maybe slightly unique in Africa are the patents of importation that are possible. So in Ethiopia and the DRC, so those are the countries highlighted in yellow, it's possible to take a granted patent from any jurisdiction and basically register it in the DRC or Ethiopia. So this can be quite useful if you have not paid a lot of attention to having an African IP, African patent portfolio, and a couple of years down the line you decide actually these countries are, of significance and importance to you. We've had a client recently who basically took assignment of a large portfolio and established belatedly quite a significant and sizable portfolio that they're going to use, for their licensing revenue. So, I mean, I don't think that it's possible to do that in many places. So I think it's just something, from a strategic perspective, that can be quite interesting and something maybe to just to bear in mind. So obviously the biggest economies in Africa, being Nigeria, South Africa, and Egypt, are not part of any of these regional organizations. And obviously, when we look at the sort of popularity of where we see the most filings, South Africa by far has the highest number of patent and design filings on the continent. And recently, actually, we've seen a significant surge in filings emanating from China. And that's because we have obviously a registration system only for those of you who have filed patents in South Africa. We've got a registration system only, and so we can get granted patents within maybe 3 or 4 months sometimes, which is incredibly fast. And although that's not exactly what we would say would be our sort of preferred route, because we have some rather unusual provisions in our laws that can lead to invalidity and stuff like that. It can be useful, and sometimes having a granted patent can open up access to government grants or state grants, and so that is what some applicants are looking for. I've spoken about the patents of importation, so I think we can go to the next slide. So what we want to do here is just give you a brief overview, and I know this is quite sort of dense on information, so just very, very briefly. What we see from sort of inquiries and stuff that come in to the firm is often a confusion between the difference between a repo from a trademark perspective and the different, and from a patent and design and utility model perspective. So basically with a repo, the Lusaka agreement is the agreement that anyone who wants to join a repo, any country who wants to join a repo will sign up to the Lusaka agreement. But once you're a member of the Lusaka agreement, it doesn't mean that you can be designated in a trademark or a patent or design application. Those countries, once they've acceded to Lusaka agreement, then have to accede to the Banjul or the Harare Protocol, which would then allow them to be designated in a patent or design application. So that's really the trigger. And so you'll see there from that table on the right-hand side, all of the ARIPA member states, and there are 22, and just to correct Ogie, sorry, Ogie, Cape Verde isn't quite a member of ARIPA just yet. It has signified its intention to sign up to ARIPA. So ARIPA currently has 21 states. Sorry, Ogie. ARIPA currently has 21 states. Currently has 21 states, but Mauritius and Somalia, who are ARIPA members, cannot be designated in any applications at this stage. So they haven't signed up to the Harare Protocol, which deals with patents, designs, and utility models, and they haven't signed up to the Banjul Protocol either, which deals with trademarks. There are two other working protocols, two other protocols, one of which is in effect, which is the Swakopmund Protocol, which deals with traditional knowledge. We can go on to the next slide. Swakopmund Protocol deals with traditional knowledge, and the Arisha Protocol, this protocol isn't yet in effect, not in force. It requires 4 member states before it can come into effect. So we are looking forward to the day when that does come into effect, because the issue of plant varieties is something where we do need sort of more regional approach. It is very difficult. It's difficult to get information. It's difficult to actually find sort of local counsel who have experience in this kind of with plant varieties. So capacity is lacking, and it would be really useful for clients, I think, to be able to register their plant varieties through a central system like a repo. Where are we? Sorry. I think we can move to the next slide. Okay, so again, the Africa map shaded here. So these are the countries that are members of the Harare Protocol. So in any of the countries listed here, you can file an ARIPA application centrally at the ARIPA office, which is located in Harare, in Zimbabwe, and you can designate one or all of these member states. So I think one of the important things about ARIPA, just from a strategy perspective, and I mean, there are more slides on this, but let's just touch on it now. There's 19 member states, but you don't have to file with all 19 member states, unlike in RRP. So with ARIPA, the cost of filing has a significant impact. Sorry, the number of states designated has a significant impact on the cost of filing. So you can choose 5 or 6 of these states where you've got a particular commercial interest, or where you think, those are the countries where you're operating and when you have operations, and you can say that that's where, the states that you want to designate. Especially with PCT regional phase applications, which is the majority of the cases that we see coming through from for repo. The number of states has a massive impact on the cost of filing, because we must back pay accumulated annuities. So just from a strategic perspective, I think look at the states that you want to designate, and then also just be aware that for PCT regional phase filings, it's not possible to add additional states once the application's been filed. So if you are overcautious and limit your states too much, so it really is a bit of a balancing act. If you're overcautious and limit your states too significantly, then you may end up in a position where you won't be able to extend that application to any of the other repo member states. The cost of the annuities does increase quite significantly as the patent matures. So what we advise clients, if they're not 100% sure, is maybe to designate all states on filing, and then later you can drop states as the cost of annuities per state increases and becomes a little bit prohibitive. So I think that's maybe not a bad strategy to consider. So I am, or we are, huge fans of the repo system. We work very, very closely with repo. The office is organized and they're efficient. I know, and Simon will touch on it when he gets to the slides dealing with trademarks. ARIPA has had, I guess, a bit of a bad rap when it comes to trademarks. The take-up on signatories for the Banjul Protocol has been slow, and there have been issues and concerns about domestication and whether trademarks registered by ARIPA are enforceable. The Harare Protocol, I'm very happy to say, is not plagued with those same problems and concerns largely. Most of the states, if not all of them, have domesticated the legislation, and because the national IP offices receive and process so few patent applications and design applications, there really is a lack of capacity. So ARIPO is a much more attractive option than filing in most of the ARIPO member states, with a few exceptions. I think the Kenyan Patent Office operates really well, and we have no problem recommending to clients who only have an interest in filing in Kenya to go direct. But most of the other member states, from a Harare Protocol and patents perspective, really have very limited capacity when it comes to patents and designs. I mean, in some ARIPO member states, we have had cases that have remained pending for the entire duration of the patent. So obviously, that's not something that that we would like to encourage clients to get into. And so in certain circumstances, we may recommend to clients that they should file nationally, but by and large, an ARIPO filing is to be preferred if you're looking for patent or design protection. Just from a sort of policy level, ARIPO really has been very effective in building capacity in the IP fraternity in Africa. There's very few IP sort of dedicated resources, and scarce, those kinds of resources are scarce. ARIPO has really assisted in, sort of upskilling the IP fraternity in Africa. They offer masters in intellectual property to candidates from the ARIPO member states, which has a really good take-up every year. So, I mean, we believe it's certainly an organization that should form an essential part of any IP strategy, certainly a patent and design strategy in Africa. I think we can move on to the next slide, please. Okay, I think I probably covered most of this. Head offices in Harare, Zimbabwe. You can file single applications. So Seychelles is the most recent state to become a member of the Harare Protocol. It became a member of the Harare Protocol on the 1st of January 2022. So currently you can designate the Seychelles in a design application, or a convention application or a non-convention application, but not yet for PCT regional phase applications, because the international filing date must be after the 1st of January 2022. And for those of you who are familiar with PCT filings, there is a bit of a lag before that's going to take place. But it's a nice block of countries. And just by way of explanation, just to tie back to what Ogi was saying, the combined GDP of the ARIPO, 19 ARIPO member states is over $1 trillion. And the combined population is, I think, over 370 million people. So it's not an insignificant market if you look at it collectively and holistically. If you look at it individually, you may think, that that's not a country that has a particularly impressive, prospects from an economic perspective. But I think holistically, if you look at it as a group of countries, it really is something that's quite significant. Sorry, so we touched on that. We can file nationally order repo. Enforcement for any ARIPO patents would be according to the national laws of the member states, and obviously you're going to enforce if there's an infringement in a particular state. You're going to enforce in that state, and there has been successful enforcement of ARIPO patents in Nigeria. Not Nigeria. Nigeria is not a member. In Kenya, that was a pharmaceutical patent. It was a Pfizer case. Oh, my lights have just gone off. A pharmaceutical case many years ago. So there hasn't been a lot of litigation, but I think that is always good to just mention that it is possible, rights are enforceable, and that's something that we often get asked. The working language in ARIPO is English. There's no need for any translations, except for the very frustrating and cumbersome requirement to validate a ARIPO patent in Sao Tome, where we have to file a Portuguese translation. So that is a little bit unusual, because none of the other ARIPO member states require any kind of validation process. So, I mean, that does increase the cost of designating Sao Tome, and that is something that we do recommend to clients that if they're designating Sao Tome, they do consider that, because it is going to be quite a significant translation cost down the line. Thank you. Next slide. I think from a filing strategy perspective, when it comes to a repo, these are really the most important things, and I have touched on most of them. You've got to look at the designations very carefully. Don't be like overly frugal, and make sure that you cover the territories where you have realistic prospects of wanting to seek patent protection. Look where you might want to seek national versus regional protection. There might be reasons such as cost. There is a particular client, a pharmaceutical client, who was paying very, very high surcharges in a repo because surcharges are levied on claims and pages, who's now filing directly rather in Kenya because the surcharge calculations are quite different and they save quite a lot of money. So sometimes, and like I said, very limited circumstances, we might recommend national filings, but most of the time a repo would be preferred. Surcharges, we have to go, yes, surcharges are significant. We do try and justify the fact that it is 19 states that we're getting protection in, and then we are required to file a request for examination. I think we can move on. Okay, repo designs. So as far as we're concerned, the repo designs are probably the best kept secret on the continent. I think, unfortunately, maybe they have fallen in the same category as the repo trademarks, which have got a pretty bad, which haven't got the best reputation historically because of the problems with accession and stuff. But really, repo designs, because they're dealt with under the Harare Protocol, they fall under the same system. Domestication isn't really an issue. There are a couple of countries, I think Tanzania, where there's some concern, and that's just simply because of the setup and the sort of political arrangements in Tanzania, where you've got two separate registries. We're not sure if necessarily a repo design registration extends to both mainland Tanganyika and the island of Zanzibar, and then a country like Liberia, where there's some concern about the current status of their laws. But really, a repo designs, they proceed to registration within 8 to 12 months. The cost of filing is incredibly low. I mean, you can get for each additional designated state, and it's quite funny because it's very different to a repo patents. With the repo patents, the cost of designations is significant, and we're quite cautious when we're telling clients, whether or not to designate all states. But on the contrary, with a repo designs, it's only $12. I mean, I don't know what you can buy for $12 on the IP front, but certainly not a design in a country. So, it's $12 to designate an additional state. And so, the official fees really are low. The process is quick and efficient. And it really is something that we would like to encourage clients to consider as part of their portfolios. Again, you can look at national versus regional protection. Similarly with the patent system, you can elect to file in a repo design, designate one or all member states, or you can go nationally. But really, when you're looking at $12, I don't think you're certainly not going to be able to register a design in any of the repo member states for $12. So really it's a great system. It operates well. You can get speedy registration, and it's something that we think is often overlooked. Simon, I think the next slide's for you.
Yeah, thanks, Nikki. So just, and Nikki alluded to it, as did Nishan, from a trademark perspective, and as Nikki said, we must not get confused with designs and patents where the repo system works well. From a trademark perspective, not quite as efficient, no fault with the repo office. As Nikki said, the repo office works really well. On the trademark side, exactly the same. Functioning of it is great. They're amenable to changes, and there's been, and I'll mention it later, there's been some significant changes quite recently, in fact in 2022. But there are a few fundamental concerns with the repo, which I'll touch on. But just briefly, so Nikki mentioned that there's the various protocols. The Trademark Protocol is the Banjul Protocol, which was adopted in 1993. But there's been fairly slow uptake on that protocol. 12 countries have acceded, but there's only really, in our mind, five of those countries where you can effectively protect your rights via the repo system. And it goes back to really, it's a domestication of law problem. Until such time as the other member countries have amended their laws to recognize the repo registrations, there is some risk in going the repo route. Obviously, from a cost perspective and a filing strategy perspective, you might want to do it. And sometimes we say to clients, well, from a defensive perspective, there is some merit in it, because from a cost perspective, it's not expensive at all. So we normally encourage clients to designate all 12 countries, but we will make the point that it's probably only really effective in the 5. And if you're actually selling product or offering services immediately, you might want to think about doubling up with the national filing. And as I say, it's not particularly expensive. And a repo filing plus a national, say in a country that we're concerned about, will not be expensive at all. And that's almost the belts and braces approach, which I think might be a good approach. I think, as I said, it's not a repo's fault. I mean, there's multiple discussions, and it happens every year where member countries are encouraged to amend their laws. But there's an amendment of the laws, and there's also the sort of the digitization of records. They need to be able to, the registries need to be able to function effectively and get the notifications through to the repo head office in Harare, quickly, seamlessly, until all records are completely digitized. This is another stumbling block, and it's a work in progress. I mentioned earlier how well we've done on the continent legislatively, but in terms of automation, streamlining of the trademark, of the IP offices, there's still some work to be done there, and that's probably a bit of a hamstring in terms of effectively working on, for example, on a repo, and the same will apply later when I talk a little bit about Madrid in Africa. It's the same sort of issues. Nikki mentioned the processes, and I'm not going to go into that, but effectively it's a designation process, unlike a RP, which we'll get to in a second, and has already been mentioned. It's basically, as I say, my approach would be to designate all 12. There is an examination process. Everything's got to be done in terms of the national laws. Enforcement, opposition, etc. is all done at the national level, and really it's really a process that must go through the head office. There are regular amendments to the Banjul Protocol, and as I mentioned earlier, quite recently there's been, with effect from January of this year, some significant changes, introducing time limits. If you haven't done something, your mark potentially will lapse or be withdrawn. Registration, if there's been no examination within a 9-month period, it will automatically go through to grant, which is a similar approach to Madrid. It sort of just does away with these sort of applications that just lie there pending, and are not. So that's, I mean, I say Repo is doing everything it can from its side procedurally to move things along, but really the stumbling block is unfortunately at national level, where we need to continue, and we do continue to encourage the countries, and we've offered, as a Repo, offered to assist in terms of helping with the amendments, getting WIPO involved. There's various organisations that are happy to get involved, but that remains a bit of a stumbling block. Another amendment that I've just remembered was when you file an application, and I think it's a good thing, but prohibits bad faith filings, is you must have a declaration of intention to use, a bona fide intention to use, or that you must indicate that the mark is in actual use. So they are tightening up on procedures. So our gripe doesn't sit with the Repo. Our gripe really is at the national level. Before we move on to RP, just Sarah, if I can bring you in here, just from a client, and it's not particularly a Repo related, it's more just an overall perspective. What considerations are factored in when looking where to file a trademark in Africa? I mean, what do you guys generally at a business level, how do you make your call?
Yeah, thanks, Simon. So a lot of it, as is probably no surprise, is driven by what's important to the business and their strategy. They give that feedback to us, and then we look at how we can put that into play and figure out how we can get the necessary rights to protect those interests. And also cost is really important too. So knowing that it's fairly inexpensive, it means we can file more, like looking at the ARIPO and the national filings too. Yeah, that's an important consideration, and also looking at what's actually happening in the market. So if there's particular countries, it might make sense to have more protection there, and again perhaps broader or slightly innovative filings again, just to kind of look at what's going on and seeing what makes sense in our decision-making process there.
Cool, thank you. Right, next slide, please. I don't plan to spend too much time on this. We've had Canada Africa map, and Nikki's mentioned this as Nishan, 17 member states. Perhaps we can just move to the next slide, just in terms of some of the, and as Nikki mentioned, all the countries are exactly the same for designs, trademarks, and patents. Just a quick overview there, and I'll say we haven't mentioned this all before, but just bear in mind you cannot file in Mauritania, Niger, Benin, Burkina Faso, Mauritania, whatever. You can only file a single application, covers all 17 member countries. Those member countries have announced their national laws, so that makes it quite simple. There's no designation process. Enforcement, just bear in mind. So, for example, so your from filing to grant is before RP, oppositions or before RP. But if you want to enforce your rights, i.e., where you need to get a Nishan involved, that's going to be at the national level, where you need to go to the national countries where the infringement took place. As we've mentioned, the system is really efficient. It works really well, and as we mentioned, it's really one protocol. There was huge changes that came into force earlier this year, which were really a game changer as far as the RP is concerned. It moved it from what was previously a deposit system into a much more vibrant type of engaging system with with substantive examination, relative examination. They moved the opposition term, which used to be post-registration, during the prosecution of the application, which made a lot more sense. So there's been some really good changes there. It used to be probably the only country in the world, or region rather, in the world where you couldn't file goods and services in one application. You had to file them separately. So it was very confusing. It was a multiple class system, but you couldn't file goods and services in the same application. That's been done away with. So there's some really, sort of make sense changes that they've brought into the system. I still have an issue with their having joined Madrid. They joined many years ago, and the changes have been incorporated into the Bangui Accord, except all 17 countries need to sign the agreement, the Bangui Agreement, and not all 17. So there might be some cause for concern there if you're enforcing Madrid registration, but it's for all intents and purposes at the operational level. It remains to be seen if this was ever be tested. At the operational level, it's working. In the Madrid system is working. Right, we did get this before we move on. This question by the audience pre the webinar. It was what can be done to speed up the process in RP. In fact, and Nikki will agree with us, it actually works. I mean, speed-wise, it actually works fairly well. There's no significant delays at all. There was a time where maybe our receipts, they call them quittances, used to be a bit delayed. You're filing receipts effectively, but other than that, it works really well. Probably on the trademark side, within 12 months, you'll get your grant. In fact, it's probably moving closer to 9 months, including a 3-month opposition. So I think the system actually works as well as it can, bearing in mind it's a big operation. They're paying the official fees to 17 countries. There's quite a lot of admin involved. So actually the system works really well. Right, Nikki, over to you.
Thank you. No, Simon, I would definitely agree with that. On the patents front as well. In fact, it works too well sometimes. One of the things I've actually put it down on the slide here. So there's no substantive examination in RP, unlike a repo. Sorry, there was a question that came in during the course of the webinar now about examination in a repo. I think I did answer that on the slide, even though I may not have actually said it. So a repo conducts substantive examination, but RP doesn't. So it is a deposit system, a registration system only. And like I said, almost the patents go to grant too quickly. I think at the last statistic that we got of the cases that we had on our records was that cases were actually going to grant within 5.5 to 6 months. And I mean, for anyone in the patent world, I think everyone would agree that that's probably a little bit too fast. We would typically like an opportunity to look at what happens in corresponding applications in other jurisdictions. So, clients are really our recommendation really is to clients that they must take a very proactive approach. And in fact, before we file an RP, we recommend that we look at filing amendments and consider if a divisional is going to need to be filed, because most of the time you're going to probably have less than 5 or 6 months to do that, which is quite unusual when you're filing and prosecuting patents. So yes, there's certainly no undue delays. I think that the undue delays that we have seen, and obviously with COVID, the RP patent office basically didn't issue any certificates for 2 years, and we are now getting boxes of the certificates coming through. So latest patent documents are coming in fast and furious. The system in RP is a little bit unusual and unique. The publication takes place in the bulletin, and then the certificate is issued after that. So we get sort of a soft copy that we download automatically from the journal, but the certificate can take a while to issue. So I guess that's the only delay in the issuance of the certificates, although I must say we have we're still sort of working from home, but the Thursdays are our office day for our team. And I was told that there's about, a big boxes coming through. So things are improving, and our RP is definitely working hard. Again, it's like a repo. The system works well. The official fees are high at our RP, and certainly when you look at filing, pharmaceutical specifications where you've got pages and sequence listings and hundreds of claims, sometimes the cost of filing can be significant. But there are strategies to try and reduce the surcharges payable to our RP. We do a sort of pre-filing review, so we would look at reducing the surcharges to the extent, greatest extent possible. But again, you're looking at an organization with coverage in 17 jurisdictions, so certainly worthwhile from our perspective. Similar to a repo, with the exception of Sao Tome, there's no validation procedure post-grant in our RP. And we have seen a significant increase in filings in 2021, actually about a 27% increase in filings, which actually mirrors the repo statistics. And that's good for us, it's good for the regional systems, and hopefully it signifies, growing economic interest in the continent as a whole. Our RP covers, all forms of IP, like we said. Designs also work well under the RP system. They proceed to registration very quickly. And again, cost effective. Sarah did mention that, obviously clients will look at costs. We're hardly ever at the top of anybody's filing list down here in Africa, but where we do make it onto the filing list, cost is expensive. Cost is obviously important. And when filing designs at RP, you can file one application for up to 100 designs. So, cost effectiveness when it comes to designs, I think, the regional systems definitely deliver on that front. Next slide, please.
Right. I realized we're sort of almost running into extra time, yes. And there's quite a lot of information here, and I'd really the point I want to make is that, and Nishan mentioned it when he was talking about the dangers, we call it the pitfalls of relying on the Madrid Protocol system in Africa. And I've just used a traffic light system to give you an idea. Nishan mentioned those 4 countries where it's probably fine. Even there, maybe people see me as an eternal pessimist, but even in those 4 countries, we picked up issues. For example, Morocco and Tunisia, I was at those registries, and there's no examination taking place of IRs, I can tell you that. They just wait for the default position, which is to go to grant. So there's really a mixture here. You've got countries that have amended legislation procedurally or just nowhere. You've got countries that haven't amended their law but procedurally do quite well. So it's a bit of a mixed bag, but bottom line is there's very few countries you can rely on. So if you're serious about protecting and enforcing your rights in Africa, almost across the board, you need to rethink that strategy. That strategy must be a mixture of Madrid, like I mentioned with the repo, with national filings. For example, if you're actually actively selling products, offering services, I would be hesitant to go down this road. And perhaps you just need a chat about the countries, and we can work out a strategy on that front. I know there's argument that often gets raised. Well, we've joined Madrid. Constitutionally, it's fine. We've got a monist system where international law is deemed to be part of the law. That's all good and well. My difficulty with that is that's fine, but if you haven't got a national law recognizing rights, where the procedures, systems, how do the courts, what jurisprudence is there for the courts to work on? If there's no local law, you're relying on international law. It just makes no sense to me. So, until laws are properly in place, it's my concern. Madrid remains a problem. So there's a lot more I could say about that. We're running fast out of time, so let me move on and ask quickly, getting back to Sarah, and it's nothing to do with Madrid. It's more just it's actually theoretical, because at the moment you can't do it in Africa, and I think it's something that we need to strive for. Is what would Caterpillar's approach? How would Caterpillar approach a decision to file an application for a well-known mark, if it were possible? I know there are a few countries where it is. India, China spring to mind, and Africa. I know there's, it does come up, and some judgments do declare mark as well known, but from a prosecution perspective, it's still not possible. And I think it would be great if we can get there. But how would you guys typically approach that?
Yeah, no, I too agree with you, Simon, that it would be great if we could file an application in Africa, in some of the territories. I think we would just approach it as, if it were possible, it would be a tremendous benefit, as it would be to, I'm sure, many different companies and clients out there. It just gives you that broader protection. Yes, there's all the burden of the evidence gathering and things that would have to accompany that, but it just means that we can take a broader view to enforcement, and also with a larger company, if they're expanding into new industries or new product lines, again, it sort of saves having to make tremendous global filings everywhere for perhaps one additional new product that's come out. It just gives you that broader chance, I guess, to kind of have it there without actually having it in necessarily a trademark registration. So I keep my fingers crossed that in the future maybe there will be some opportunity to do that, but I guess we have to wait and see.
Yeah, see what happens. Thank you. Right, Nikki.
Okay, very quickly, because like Simon, you said we are running out of time. There's a similar story. Sorry, this slide can be updated before it's sent out. This is actually a previous version, but there's pretty much a heat map here. Also, the same problem with Madrid is mirrored on the Hague front. So obviously the Hague Agreement is similar to the Madrid system, but for registration of designs. There are no countries. Well, there's 9 signatories, or 8 countries plus our RP, which would be 17 countries plus the 8 individual countries that are members of the Hague system, and not a single one of them, from the information that we have to hand, has married their national laws with their international obligations and their processes at their sort of national design offices. So similar to Madrid, we're not sure if any enforceable rights would be granted. So we would definitely recommend against relying solely on international registrations through the Hague Agreement for a design portfolio on the continent. Next slide, please. And I think, Simon, that's yours, and then we're done.
Yeah. So this is just very briefly, and it just really goes back to my original point about the importance of trademark registrations. And really, if you're looking at, and I'm not going into this in any detail at all, and this is really just illustrative, it's not exhaustive at all, but you'll know when you're entering a market to sell products or offer services that there's a huge amount of regulatory requirements, and certain, really the equivalent, I suppose, of the FDA in the US, the EMA in Europe, and so on. And a lot of these applications, these process applications that you require, need to be accompanied by a trademark application, or in many instances a trademark registration. So it's really just making the point that when you are entering a market, remember the regulatory stuff, and accompanying that a trademark application or registration. And similarly with the Nishan mentioned it, recordal of license agreements is an absolute necessity to be enforceable against third parties in most countries. It's either a definite or it's recommended. Very few where it's not. I mean, South Africa is, for example, one where use by the third parties need to be used by the proprietor. So, but there's not very many of those. So again, it's really the necessity to record a license agreement to be enforceable. That's it on that slide, and then just sort of a quick wrap. A last slide on our side, just some key points. Oh, what happened to our Did we not have our key points? Sorry, if we're gonna slide ahead there.
I think this is just the previous version, Simon, so I think we can just end there.
All right, so really from my side, there's from a strategic perspective, you need to adopt a bit of a unique approach. There's multiple systems to look at and considerations to bear in mind when you're needing to protect your trademarks, and similar would be on the patent and design side. I don't know, Nikki, if you had anything to add.
No, I mean, just the key takeouts is, the regional systems work well. Repo and RP certainly, repo on the designs front and the patents front, we believe it's cost effective, it's effective, efficient. It provides predictability from a cost and a time perspective, and as alluded to by Sarah, when you running an in-house IP team, ease of renewal, ease of managing your maintenance portfolio, things like that. Those are all, things that should be taken into account, and I think it certainly ticks all the boxes.
Cool. I think that's. I don't know if there's those questions. I don't know. There's a next slide there. I don't know. I mean, we can quickly just answer those. We do get this query from time to time, whether you can file an application covering the East African community or ECOWAS, which is the West African. Those are just really trade blocks, but no, there's really only 2 regional systems. That's an RP on a repo. Will South Africa and Nigeria be joining Madrid? Not sure when. South Africa. So I think South Africa is doing it the right way. They want to make sure that their registry is in a good space, completely digitized, which they pretty much are. And the amendments are there, so it's really just it's a timing thing. Nigeria, they obviously some work to be done on their legislation, which has been outstanding. New legislation has been outstanding for many years, and I guess when that happens, they'll probably be joining up. Nikki, I think the other 2 are yours.
Yeah, well, I think the next one, the last one, I think we've answered. When will substantive search and examination be introduced for patents in South Africa? Well, I mean, there have been some developments this year. So we currently have a sort of trial program. There have been examiners in training, going through various programs and working with different patent offices across the world to become sort of qualified examiners. We do have a trial program running at the moment where the patent examiners are issuing examination reports on certain cases. We're reporting them to clients where clients have accepted being informed of those, because obviously sometimes it does bring up issues with disclosures and novelty and duties of disclosures in the US. So not all of our clients necessarily want those sort of informal reports, because as far as they're concerned, they're not informal. But the system, we actually don't know. We support it fully. It certainly is about time that South Africa introduced substantive search and examination. We certainly have the experience and personnel, and there's a lot of interest in patents in South Africa. So hopefully not in the far too distant future.
Brilliant. Thank you very much. Thank you for your insights today. Now, we have had a number of questions in from the audience, and I think just looking at the number of people still with us, they're still keen to hear your thoughts. So I think that we can spare 5 minutes to answer some of those questions. So Nikki, if I go back to you to start, can a patent of importation be based on any granted patent in DRC and Ethiopia?
Thanks, Dan. Just very quickly, in DRC, yes, it's indiscriminate. You can register any granted foreign patent as long as it's enforced. In Ethiopia is moving, doesn't currently conduct substantive examination of its own applications, but will not accept a patent of importation from any countries where the jurisdiction is non-examining. For example, we can't register a South African patent in Ethiopia because it didn't go through substantive examination. So we would recommend to clients that they wait for grant of a corresponding European or US patent or Australian patent or anything that goes through examination. So that's the only sort of caveat to filing importation applications, but a very useful tool. Yeah, thanks, Dan.
Brilliant, thank you, Nikki. Nishan, I'll come back to you next. In relation of the mandatory registration before ACA in Kenya, please clarify if these apply to all IP rights or only for trademarks.
Thanks, Dan. Sure, this is actually a hot topic at the moment. So just to give the entire audience some background, there has been regulations passed in Kenya, which makes it an offence to import any goods into Kenya bearing an IP right that has not been recorded with the Kenyan Anti-Counterfeit Goods Authority. So I mean, any clients on the call, if you're exporting goods into Kenya, please, this is relevant to you, because essentially what can happen is original goods going into Kenya can be stopped by the Anti-Counterfeit Goods Authority in Kenya if your IP rights are not recorded. So going back to the question, what forms of IP rights can be registered? Well, in theory, all, because the regulations are quite wide. What we're doing in practice is we are recording trademarks. We're recording trademarks at the moment, and the reason for that is, I mean, if you think about an Anti-Counterfeit Goods Authority or counterfeit goods, essentially we're talking about infringement of trademarks. So we started off with recording of trademarks.
Great, thank you, Nishan. Simon, how do functional IP and trademarks apply in protection, especially in other regions?
I'm trying to understand that question. Sorry, just Dan, repeat it again.
How do functional IP and trademarks apply in protection, especially in other regions? I don't know if that question came through when you were speaking about a specific item. If not, we can sort of get back to the person who asked that question at a later date, and we can.
Yeah, I'm trying to work out whether they're trying to work out what the difference is between maybe patents and trademarks, but that, I mean, I don't know what else it could be alluding to.
Yeah, that's absolutely fine. Sorry, Nikki. Yeah, that's absolutely fine. We can go back to the person that asked that question after this session. And just to let everybody know that you will receive a recording of this webinar after the session, along with the contact information of the panel. I know we've had a lot of questions in today. If you did ask a question that we didn't have time for, we will certainly be in touch afterwards to help you get that question answered. I think that we'll finish on this final question to Nishan. What constitutes a well-known trademark? For instance, how do you acquire the well-known status for a trademark? Is this something you would apply for, and is it country specific?
Oh, thanks, Dan. So, I mean, there's a series of questions, but I'm going to go back to the test which is really set out in the Paris Convention. And I mean, a well-known trademark is essentially a mark or brand that is known by a substantial number of persons in the concerned industry. That's a legal test. Unfortunately, you can't apply for it. I think Sarah and Simon touched on this. You can't apply for well-known trademark status. What you need to do is, when you want to enforce a well-known trademark, you got to prove it each time with reference to evidence. So every case, unfortunately, you got to get that evidence piled up, and you got to prove that the trademark is well-known. And that applies, going back to the question, that applies to every country. Trademarks are territorial, so the fact that you've proven your trademark is well-known in South Africa doesn't mean it's necessarily well-known in Botswana. You got to do that all over again. So that's
Brilliant.
it there.
Brilliant, thank you, Nishan. I think that's a fantastic place to end today's webinar. On behalf of everyone at Mondaq, I'd like to thank the team at Adams and Adams for helping bring everything together today. A special thanks also goes out to Nikki, Nishan, Simon, Ogie, and Sarah. Your insights, time, and presentations today have really been fantastic, really greatly appreciated. As I say, we will be providing a copy of today's slides along with the recording and the panel's contact information in a follow-up email. So if you did have a question that we didn't have time for, if you have any other queries that you want to run by the panel, you can get in touch. And I'd finally like to thank you all for being with us today. I hope you can join us again soon. Goodbye.
That's right.
Thanks, Dan.
Bye-bye.